Always. For example, suppose you tell this to the police. Here's what your client tells to the police in his denial of guilt. I don't know what you were talking about. I didn't kill Jones. I don't know who did. I wasn't anywhere near that place. I don't have a gun. I've never owned a gun in my life. I don't even know how to use a gun. Yeah, sure, I never liked the guy, but who did? I wouldn't kill him. I've never hurt anybody in my life, and I would never do such a thing. Let's suppose every word of that is true. 100% of it is true. What will the jury hear at trial? Officer Brook, was there anything about this, your interrogation, your interview with the suspect that made you concerned that he might be the right one? Yes, there was. He confessed to me that he never liked the guy. And then the prosecutor will put that up in big letters, and he'll say, ladies and gentlemen of the jury, it's pretty clear that we've got the right guy here. We've proven that he was in Virginia Beach that night. That's opportunity. And remember, Officer Brook admitted that after extended questioning, he was finally able to get the defendant to admit that he never liked the guy. There's your motive. Motive plus opportunity. Wham, bam, please. But juries eat it up. And innocent people get convicted this way sometimes. How often? Hopefully not too often, but we know what happens. The United States Supreme Court, don't take my word for this. In Ohio versus Reiner, the Supreme Court of the United States said, quote, one of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence from the speaker's own mouth. See, it's not just some criminal defense attorney telling you this. Even the Supreme Court says I'm right. Under the facts of that case, by the way, in Ohio versus Reiner, a child tragically was died, apparently the result of shaken baby syndrome. The question was who had shaken this baby to death. And one of the possible suspects was a babysitter who had spent some time with the child that week. The babysitter's story was, I don't know what you're talking about. I did not kill the child. I did not see it happen. I don't know who shook the baby. It was never me. I never did anything of any violent nature to the child. The Ohio State Court said, well, you've got no Fifth Amendment privilege. You, by your own admission, told the investigators that you've done nothing wrong, that you were not involved, so obviously your answers can't incriminate you. The United States Supreme Court reversed and said, well, that's not true. Even though this babysitter denies shaking the child, denies seeing the child die, denies knowing how the child died, this babysitter, by her own admission, apparently the government wanted to ask whether the babysitter might have been with the child at some point that week, during the week prior to the death. And that answer, although by itself not sufficient to convict anybody, could help convict her. That means she's got a Fifth Amendment right to refuse to answer to the question the court held, because it could be used to help convict. Ullman versus United States, the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been. But it gets worse. Can it get worse? It can. Number 5. Even if your client is innocent and only tells the truth and does not tell the police anything incriminating, which, by the way, is almost impossible to pull this off. I mean, imagine talking to the police for 2, 3, 4 hours, and somebody like him can't somehow manage to extract from